I'm here with former DUI enforcement officer Michael Scafidi, who's now the top DUI defense lawyer here in Barstow. And Mike, I know that you've successfully defended many people who have gotten DUIs here in Barstow, in the Barstow courthouse. If somebody does get a DUI here in Barstow, if they do get convicted, what sort of penalties are they looking at?
If you suffer a conviction in the Barstow courthouse, you're looking at 4 consequences. Number 1, they're going to be on informal probation. Number 2, they're going to have to attend the AB 541 class, which is a first-time offender 3-month program.
DUI school.
DUI school. The third thing that's going to happen is they're going to spend 2 days in county jail. Normally, they'll get credit for 2 days served. And finally, they're going to pay a fine of about $1,900.
So in terms of the jail, what you're saying is normally they won't have to do any more jail time other than when they got arrested.
That's correct. When you get picked up, you're normally in jail for 5 to 8 hours, sometimes 12 or so. You're going to get the 1 day plus a 1 day credit for a total of 2.
So if you get a second time DUI conviction, the penalties are much greater.
They are. You're still going to have that, number 1, the summary probation. 2, you're going to do jail time. That can range anywhere from 10 days up to 60 days, depending on the circumstances of the arrest. You're going to also have to attend now the longer DUI class, the second offender program, which lasts 18 months.
So an 18-month DUI school.
Correct. You're still going to pay those fines, and you're going to have some driving terms added on that are going to have more consequences than a first-time offense.
And you said 10 to 60 days jail. So now you are looking at additional jail time beyond the arrest.
You are. It's 10 minimum. Generally, you'll see up to 60.
And a third time DUI conviction, then it's exponentially worse, right?
It is. You're going to have, again, the probationary period, number 1. Number 2, you're still going to have that statutory fine. 3, you're going to do jail time. It's minimum under statutory law in California to do 120 days in county jail. Typically, we're seeing in San Bernardino County between 120 and 270 days in county jail.
So 4 to 9 months jail, basically.
4 to 9 months jail, exactly.
And the longer DUI school.
And the longer DUI school. In fact, oftentimes on a third offense, they won't even give you the second offender program because DMV is going to revoke your license.
So let me ask you this, Mike. You've had a lot of success defending clients who are charged with DUI in San Bernardino County.
We've had great success.
And what are some of the things that you do to help clients win cases?
We subpoena the officers to the DMV hearing. We cross-examine them. We subpoena the videos that are in the most police units now.
The videos that sort of depict the roadside DUI investigation.
From the observations a minute prior to the stop being made, to the roadside contact, to sometimes the field sobriety test. We also subpoena any calibration and maintenance records for breath machines, evidentiary breath test machines, and blood documents, blood run sheets if there's a blood test.
And a lot of times the breath test and the blood analysis, there's mistakes that are made that can really undermine the prosecution's case.
Absolutely. The collection of that evidence and the testing of that evidence is controlled by California Code of Regulations Title 17. And many times, in many cases that we defend, we see that the labs have made mistakes or the actual initial collection by the officers have been done in error.
So as horrible as these penalties are that you describe in San Bernardino County, if you have a good San Bernardino County DUI defense lawyer, it may well be possible to get the charges reduced or dismissed and save your driver's license.
I would agree with that 100%. No case that the DA has and brings forth is completely 100% foolproof for them. There's always things that come up to defend a case, to mitigate a case, and in a lot of cases to get cases dismissed.
Even if you blow well above the .08, the situation is rarely hopeless.
Rarely. In fact, I think some of our greatest successes don't lie with the great results we get on the low blood alcohols, the 0.8s, the 1.0s, the 0.12s. I think some of our greatest results have really occurred with elevated blood alcohol levels 2 times the legal limit, 3 times the legal limit, because then we have all these tools, resources about the technical issues, and we get the cops at DMV. There's no DA there to protect them. We basically have them under oath for hours at a time to break down their testimony.
And finally, Mike, I want to ask you about if a client does have a DUI case, about contacting you, because they may be unsure whether they want to get a lawyer, use a public defender, just plead guilty. If they want to come sit down with you, have you go over their case, give an assessment of what can be done. Do you do that for free? Is that a service that you offer?
We do. We do free consultations for people. And you know what, Neil? I made a pledge that I have kept since the day I became a lawyer 15 years ago. And that pledge was that I will give a free hour of my time to anybody who's facing prosecution in our criminal justice system. It's something that I decided to do as a lawyer and as a human being, because I have seen too many times in my lifetime, in the 32 years I've been in the justice system, people pleading guilty to charges that they're not guilty of.
So it would behoove someone, before they go in and plead guilty and get this on the record and suffer all those consequences, at a minimum to come sit down with you for an hour, go over their case, and talk about what you can do for them.
Absolutely. There's not a lot of things in life I guarantee, but I guarantee when they leave that meeting, they'll know more about their case and more about their rights than they did when they walked into that meeting.
And of course, people are struggling. A lot of people are struggling here financially. A lot of people are out of work. And some people are sort of intimidated, think they cannot afford a lawyer. Do you have like payment plans and special arrangements that you make to fit people's budgets?
We do. How we set our scale of charging people for DUI cases is I look at what's fair to the client and what's fair to us. I have a really good idea when I do an initial intake how much work is going to go into a case. I know exactly from talking to the client what is going to be involved, what subpoenas are going to be done, what testimony is going to be drawn out. So I have a really good idea. So I understand what's a fair price for the lawyering, and I look for a fair price for the client. And what we do is we do allow them to make payments.
So even if they think, gosh, I can't afford, $3,000, $4,000, $5,000 for a lawyer right now, they should still come talk to you because you'll work with them.
We'll not only work with them, plus they're going to get that free hour consultation, and they're going to leave that meeting with so much more information than if they hadn't taken that meeting.